When you live with a really bad roommate, you actually start to see property crimes in an entirely new light.
Oh, absolutely.
Like, think about the classic scenarios. You have the roommate who waits until you fall asleep, sneaks into your room, and just takes your favorite jacket.
Right, the classic sneak.
Yeah, exactly.
Yeah.
Then you have the one who asks to borrow your laptop to write a paper. You gladly hand it over, but then they just, refuse to ever give it back.
Yeah, the trust breaker.
And then, I mean, there's the roommate who looks you dead in the eye, lies about having some terrible family emergency to get your car keys, and then just drives off to a weekend party.
That is the absolute worst one.
It really is. But in all three of those scenarios, you end up without your stuff. The result is exactly the same. But the way they acquired your stuff, the actual mechanics of the taking, that is completely different every single time.
It is. And, well, that's a great framework for what we're looking at today because, human behavior is super messy, but the law really demands clean categories. And if you're preparing for the multi-state bar examination, the MBE, you already know that the bar examiners love to exploit that exact tension.
They really do. They give you these messy factual scenarios where someone clearly loses their property, right?
Exactly. And then they ask you to pin down the precise legal category. The intent across those three roommate scenarios is nearly identical. I mean, the person wants to permanently deprive you of your property.
Which seems like it should be enough to just call it theft and be done with it.
You'd think so. But if you focus on the bad guy's end goal, you will absolutely get the multiple choice question wrong.
So what's the secret?
The entire secret to unlocking property offenses on the exam is focusing exclusively on the timeline of the action, and specifically who held lawful possession of the property at the exact microsecond the crime materialized.
The exact microsecond. Wow. Well, that is the mission for this deep dive. We are taking that massive stack of outlines, the common law doctrines and bar prep materials you've been staring at. And we're going to untangle the big three property crimes.
Yes, larceny, embezzlement, and false pretenses.
Right. And we are also going to get into robbery, extortion, and receipt of stolen property. And we're doing it by stripping away all that convoluted ancient phrasing wherever we can.
Focusing just on the functional logic.
Exactly. We will point out the traps that are designed to make you second-guess yourself on test day. Because once you understand why courts created these bizarre rules in the first place, they honestly become impossible to forget.
That's the...
So let's start with the foundation, the sneak. The roommate creeping in to take the jacket. Common law larceny.
So larceny is the baseline. It's the oldest of the property crimes. And frankly, if you do not have a rock-solid grip on how larceny works, the rest of the crimes will just constantly bleed into one another.
Okay, so let's lock it down. What are the elements?
The common law definition of larceny has 6 specific elements.
Yeah.
And I mean, every single one is a potential failure point on an exam question. First, there must be a taking. The legal term there is caption, which just refers to obtaining dominion and control.
Caption. Got it. And the second?
Second, there must be a carrying away. The fancy word for that is asportation.
Okay, taking and carrying away. What's third?
Third, the target must be tangible personal property. Fourth, it must be the property of another person.
Right. You can't steal from no one.
Exactly. Fifth, the taking must be by trespass. And that just means it's done without permission or consent.
Okay.
And finally, sixth, it must be done with the specific intent to permanently deprive the person of their interest in the property.
Okay, so taking, carrying away tangible personal property of another by trespass with intent to permanently deprive. I mean, on the surface, that sounds incredibly straightforward.
On the surface, sure.
But the MBE doesn't test the surface.
Let's dig into element 3, tangible personal property, because the strict common law rule is that you cannot steal real estate, right?
Right. Real estate is land and anything permanently attached to it. So realty and its fixtures are not subjects of larceny at common law.
Okay, so if I unlawfully occupy someone's land, I'm not committing larceny. No, you might be guilty of a different crime, like criminal trespass, but you are definitely not committing larceny.
Okay, that makes sense.
But the examiners know that you know this, so they love to lay a trap using severed materials, things like crops, minerals, or trees.
Oh, interesting. Because when a tree is in the ground, it's part of the real estate.
Exactly. But when you cut it down, it transforms into severed material, which is personal property.
Okay, let me test that logic then. If I walk onto my neighbor's land with a chainsaw, chop down a massive oak tree, throw it in the back of my pickup truck, and drive away, I've taken personal property. So that has to be larceny, right?
It actually isn't.
Wait, really? How is that not larceny?
And this is where the common law gets highly technical regarding timing. See, when you cut the tree, yes, you severed it from the realty. But if the cutting and the taking away are one continuous act, the law views the entire sequence as just an act of damaging real estate.
Wow. Not stealing personal property.
Right. Not stealing personal property.
Yeah.
For it to be larceny, the item must be personal property before it is taken away. In your continuous sequence, it never really rested on the ground as personal property long enough for the true owner to gain lawful possession of it as a chattel.
So if I just chop it and drop it straight into my truck, I'm just vandalizing real estate.
Legally speaking, yes.
How does the bar examiner turn that into a larceny question then?
Well, they introduce a gap in time or a change in possession. Let's look at a classic fact pattern from the source text.
Okay, lay it on me.
So, a person, let's call her the defendant, goes onto land owned by the victim. The defendant cuts down 15 trees. She immediately loads 10 of those trees into her truck and drives away.
Okay, so that's the continuous act we just talked about.
Right. But then, the victim comes out later, sees the damage, finds the remaining 5 cut trees lying on the ground, and moves those 5 trees into a storage shed.
Okay.
Later that night, the defendant comes back, breaks into the shed, and takes the final 5 trees.
Oh, I see the trap. The exam question is going to ask what she's guilty of regarding all 15 trees, isn't it?
Exactly.
Okay, so for the first 10 trees, she cut and carried them away in one continuous action. That's severing real estate, not larceny.
You got it.
But for the remaining 5 trees, the victim actually found them. He took them and put them in his shed.
Yes. And the moment the victim put those severed trees into his shed, he established lawful possession of them as personal property.
They weren't just damaged real estate anymore.
Right, they were tangible personal goods sitting in his shed. So when the defendant returned that night and took them, she took tangible personal property from the possession of another. She's guilty of larceny, but only for those 5 trees.
That is a phenomenal distinction. The test is really looking to see if the severed item ever rested in the lawful possession of the owner as a piece of personal property before it was carried away.
Exactly. If there is a break in the action where the owner reasserts control, boom, it becomes larceny.
Okay. Now, what about the tangible part of the rule? What about things you can't physically hold in your hand?
So, at traditional common law, you cannot commit larceny of services or intangibles.
Like what?
Well, if you sneak into a movie theater through the back door and watch a film without paying, you have not committed common law larceny. The performance itself, the service of entertainment, is intangible.
Okay, that makes sense for a performance. But what about documents? I mean, paper is tangible. Can I steal a contract? Or the deed to a house?
This is another bizarre common law quirk you have to watch out for. At common law, documents and legal instruments were regarded as being merged with the matter they represented.
Merged? What does that mean?
It means that unless the actual physical piece of paper had intrinsic monetary value in itself, like the value of the fancy parchment it was written on, it could not be stolen.
No way.
Yeah. If you take a deed to real estate from someone's desk, the law says the deed merges with the real estate. And since you cannot steal real estate, you cannot steal the deed to the real estate.
That is wild.
The same applies to a written contract, too. It merges with the intangible right of the contract, which cannot be stolen.
I can hear people preparing for the exam screaming right now that modern laws must have changed this. Surely stealing a deed is a crime today.
Oh, modern statutes absolutely have changed this, and we'll get to those modern consolidations later. But, and this is crucial, the multi-state bar examination tests traditional common law rules, unless the call of the question specifically says under modern statutory law.
Right, so if the question just asks, is it common law larceny, you have to apply the merger doctrine.
You do.
Okay, let's shift to element 4, property of another, because this feels like the biggest area of confusion for students.
It definitely is.
The entire concept hinges on the difference between custody and possession, right? This is going to come up in larceny, embezzlement, and false pretenses. So what is the functional difference between custody and possession?
It's probably the most critical distinction in property crimes. Possession means having broad authority, discretion, and control over an item.
Okay, broad authority.
Right. You have the right to use it, manage it, make decisions about it. Custody, on the other hand, means you only have physical, manual control of the item, but your authority over it is strictly limited by the person who actually has possession.
So you're just holding it for them.
Exactly. You are merely holding it. And larceny requires taking the property from someone who has possession.
Let's ground this in a real-world hypothetical from the sources to really lock it in.
Sure.
Imagine you walk into a high-end clothing store. You talk to the store clerk, you find a tailored suit you really like, and you ask the clerk if you can take the suit home on approval for a couple of days just to see if it fits with your wardrobe.
Okay.
The clerk agrees and writes up an approval slip. Then, while you're still standing at the counter, you point to a very expensive gold watch inside the display case. You ask to look at it. The clerk takes the watch out of the case and hands it to you.
Setting the scene. I like it.
So now you're holding the watch in your left hand and the suit in your right hand. And suddenly you just bolt for the door and run out of the store with both items.
That is the perfect setup to test the boundary. Let's analyze the watch first. When the clerk handed you the watch across the counter, what was their intent?
Well, did they intend to give me broad authority to do whatever I wanted with the watch? No.
Right. They intended for you to examine it right there in front of them for a few moments under their strict supervision.
So they give me physical control, but severely limited authority.
Exactly. So the clerk only transferred custody of the watch to you. The clerk, acting for the store, retained lawful possession.
Okay.
So when you suddenly ran out the door with the watch, you took it from the clerk's possession without permission, with the intent to permanently deprive them of it. That completely satisfies every element of larceny.
But the suit is a different story, isn't it? Because I asked to take it home on approval for a few days, and the clerk agreed.
Yep. Because the clerk agreed to let you take the suit home, they granted you broad authority over it. You could hang it in your closet, try it on at home, leave it draped on a chair.
I could do whatever I want with it for a few days.
Right. By authorizing that broad use, the clerk officially transferred lawful possession of the suit to you. So when you ran out the door, you already had possession of the suit.
Wait, so I didn't take it from the possession of another?
Exactly. Therefore, you did not commit common law larceny regarding the suit.
That is so wild to think about. I mean, running out of the store with a watch and a suit at the exact same time, but only the watch is larceny.
It all comes down to the microscopic analysis of what level of authority the clerk handed over in the moments prior.
Okay, so how does this custody versus possession rule apply in the workplace? What if an employee steals from their boss?
Well, the general common law rule is that low-level employees only have custody of their employer's property that is used in the course of their job.
Like a cashier.
Perfect example. Think of a cashier at a grocery store. They physically handle the cash in the register all day long. They have physical control, but they do not have broad authority to do whatever they want with that money, right?
No, they're strictly handling it for the business.
Right. The employer retains constructive possession of the money.
So if the cashier slips a $100 bill from the register into their pocket, they are taking it from the employer's possession. That makes it larceny.
Correct. But there are exceptions. If the employer gives an employee exceptionally broad powers over the property, like a high-level manager who is entrusted with entire bank deposits and discretion over funds, that employee won't be deemed to have possession.
Oh, okay.
Furthermore, if a third party hands property directly to the employee, specifically for the employer, the law sometimes says the employee receives possession first before it is officially deposited into the employer's receptacle.
Oh, we will definitely see how that exception plays out when we get to embezzlement. But sticking with larceny for a second, what about people whose entire job is to take possession of goods, like shipping companies? The text refers to them as bailies.
Yes. A bailee is someone who is entrusted with lawful possession of property for a specific purpose, usually to transport it or repair it. If you hire a shipping company to transport a crate of electronics, you are the bailer, and the shipping company is the bailee.
Okay. And you give them broad authority to move the crate across the country. So they have lawful possession.
They do.
So if they have lawful possession and the truck driver decides to just steal the entire crate, it can't be larceny, right? Because
No.
you can't commit larceny of something you already possess.
Logically, that makes total sense. And in medieval England, that strict logic created a massive problem. Merchants were handing goods to carriers, the carriers were stealing the goods, and the courts couldn't charge them with larceny because of the possession rule.
Wow. It was a huge loophole.
A massive one. So in a famous case in 1473 called the Carrier's Case, the courts literally invented a legal fiction to solve the problem. It is called breaking bulk.
Breaking bulk, that sounds like a maritime term. How does this fiction work?
Let's use your crate of electronics. You give the sealed crate to the driver. The driver has possession of the crate. If the driver steals the entire sealed crate, common law says it's not larceny because he already possessed it.
Right.
But If the driver pries open the sealed crate, if he breaks bulk, the court decided that the very act of breaking open the container terminates his status as a bailee.
Oh, wow.
Yeah. The legal fiction dictates that the moment the seal is broken, lawful possession magically and instantly teleports back to the original owner.
So the driver opens the crate, possession snaps back to the owner, and then when the driver reaches his hand inside and pulls out a laptop, he is now taking it from the owner's possession.
Exactly. Taking the whole sealed box is not larceny. Breaking the box open and taking the contents inside is larceny.
That is amazing.
It's a completely artificial distinction invented hundreds of years ago just to punish corrupt Teamsters, but it's still tested on the MBE today. If a bailee breaks bulk, they commit larceny.
That is a phenomenal piece of legal history. It really shows how the courts will just twist their own rules to reach a just result. Speaking of twisting rules, here is a scenario that always bends my brain. Can I steal my own property?
Yes, you
Yeah.
absolutely can.
Really?
Yes, and to understand why, you just have to remember one phrase. Larceny is a crime against possession, not ownership.
Against possession.
It doesn't matter whose name is on the title or the receipt. What matters is who has a superior possessory interest at the exact moment the property is taken.
Let's play this out with a leased vehicle.
Yeah.
Say I own 2 cars, both fully paid off, titles in my name. I don't need the second one, so I lease it to you for a period of 1 year.
Okay.
We sign a contract, you pay me a lump sum, and you drive the car to your house. 6 months go by. I decide I really want my second car back. I call you, but you refuse to break the lease.
Which is my right.
Right. You have a legal right to keep driving it for 6 more months. So one night, I take my spare key, I sneak into your driveway, I start the car, and I drive it back to my garage.
Well, you are a thief. You just committed larceny of your own car.
Let's run it through the elements.
Sure. Did you take and carry away tangible personal property? Yes. Was it the property of another? Yes. Because you transferred lawful possession to the lessee for a year. The lessee had a superior possessory right at that moment.
Right, because of the lease.
Did you take it by trespass?
Yes.
Yes. You snuck into the driveway without permission. Did you intend to permanently deprive them of their interest? Yes, you intended to deprive them of their remaining 6-month leasehold interest. You are guilty of larceny.
The fact that I own the car is totally irrelevant because I gave away the right to possess it. So if I take it back by force or stealth, I am stealing. That is a crucial concept.
It really is.
All right, we've covered the nuances of the property itself and the possession element. Let's look at the physical act. Elements 1 and 2, the taking and carrying away, caption and asportation. You said taking requires getting dominion and control.
Yes. You must actually obtain control over the item. Mere movement without control, or mere destruction, is not a taking.
Can you give me an example?
Imagine a scenario where a person is holding a highly valuable crystal glass. You want to steal it, you reach out, but instead of grabbing it, you just slap their hand. The glass flies out of their grip, hits the floor, and shatters into 100 pieces.
Well, the owner definitely lost possession of it, and it's destroyed, so they are permanently deprived of it.
True, but you never gained control of it. You never established your own dominion over the glass. Because you never achieved caption, you cannot be guilty of larceny.
What am I guilty of then?
You're likely guilty of malicious mischief or destruction of property, but not larceny.
What if I use a trick to get control? What if I never physically touch the item myself, but I get someone else to do it for me? The outline mentions this innocent agent rule.
Oh, this is a great area for MBE hypos.
Yeah.
Imagine you're standing next to a fenced field. Inside the field is a cow. You do not own this cow. It belongs to a farmer named Y.
Okay, I don't own the cow.
Right. A stranger, X, walks down the road. You point to the cow and say to X, hey, I own that cow and I need to get rid of it. I'll sell it to you right now for $10. X, completely believing your lie, hands you a $10 bill. X then opens the gate, walks into the field, puts a rope around the cow, and walks away down the road. Are you guilty of larceny?
But I never touched the cow. I never even entered the field.
You never physically touched it, but you obtained control of the property by using X as an innocent agent. The law essentially treats X's hands as your hands.
Wow.
Because X lacked criminal intent. He honestly thought he bought the cow. He is an innocent mechanism you used to effectuate the taking. You committed the caption and the asportation through him. You are guilty of larceny.
The law treats his hands as my hands. I love that phrasing. Now, what about the carrying away part? The asportation. Does it have to be a significant distance? Does the thief have to make it completely off the property?
No, the distance does not matter at all. The movement only needs to be slight. But And this is a critical, but the movement must be part of the carrying away process. It must be a step toward removing the item.
Okay.
The classic illustration of this is the wheelbarrow example.
Walk me through the wheelbarrow.
Okay. You sneak into a construction yard at night with the intent to steal a wheelbarrow. You find 2 wheelbarrows resting upside down on the grass. You grab the first one and you flip it over so it is right side up. You moved it, it physically traveled through space. Is that asportation?
Well, it moved, but it didn't really go anywhere.
Exactly. The court says merely turning the wheelbarrow over is an act of preparation to carry it away, not the actual carrying away itself. You were just getting it ready to roll.
Okay.
So flipping it over is not asportation, no larceny yet.
Okay.
But then you grab the handles of the second wheelbarrow, you push it forward exactly 6 inches toward the front gate. Then you hear a noise, get scared, drop the handles, and run away.
Is that asportation?
6 inches, I haven't even left the yard. It doesn't matter. You achieved caption by grabbing the handles and controlling it, and you moved it 6 inches as part of the carrying away process. Any slight movement counts as long as it is in furtherance of the theft. You committed larceny the second those wheels rolled forward.
Flipping it completely upside down is nothing, but pushing it 6 inches toward the exit is a felony. That is exactly the kind of microscopic distinction the MBE loves.
Yep.
Okay, let's move to the final element. Element 6, the intent, the state of mind, the intent to permanently deprive. And crucially, you mentioned earlier that this intent must exist at the exact moment of the taking.
The exact moment. I really cannot stress this enough. Larceny is a specific intent crime, and there must be a concurrence in time between the physical act of taking and the mental state of intending to steal.
Concurrence in time.
Yes. If your intent is innocent or justified at the exact moment you take possession, it is not common law larceny, even if you do something terrible with the property later.
Let's test some mental states then. What if I take something, but my intent isn't to permanently deprive the owner? What if my intent is just to borrow it? Like, I take my roommate's umbrella without asking because it's raining outside, but I fully intend to bring it back and put it in the hallway closet that night.
Assuming you have the ability to return it, that is unauthorized borrowing. It is a trespass. It might be a civil wrong. But because you lack the intent to permanently deprive at the time of taking, it is not larceny.
What if I take money from someone without their permission, but I do it because they legitimately owe me that exact amount of money? Say my friend owes me $50 from a bet. He refuses to pay. I see his wallet on the table. I take a $50 bill out of it, and I walk away.
This is known as a claim of right. If you honestly believe you are entitled to the property as repayment for a specific debt, it is not larceny. Yes. You must believe the debt is valid, and you cannot take more than the amount of the debt. The logic is that, in your own mind, you believe you are merely recovering your own property. Therefore, you lack the specific intent to deprive someone else of their property. Wow. And importantly, even if your belief is unreasonable, even if the debt isn't actually legally enforceable, as long as your belief is genuine and honest, it negates the specific intent required for larceny.
So borrowing and honest debt collection are not larceny. What mental states are sufficient besides just wanting to keep the item forever? What if I take the property, but my plan is to eventually give it back? Conditionally. Like, I steal a dog and wait for a reward poster to go up.
If you take property with the intent to hold it for a reward, you are guilty of larceny. The same applies if you take property with the intent to sell it back to the true owner.
Selling their own stuff back to them.
Yeah. You are treating the property as if you own it, forcing the true owner to buy back their own stuff. Another scenario is if you take an item and pledge it as collateral for a loan, or if you abandon it in a location where it's highly unlikely the owner will ever find it.
Do the risk matters.
Right. The legal standard is that if you create a substantial risk of permanent loss, the law treats that as the equivalent of intending to permanently deprive.
Okay, we have covered the standard elements. But the outline has a substantial section dedicated to specialized application of larceny doctrine. These are the highly specific, borderline scenarios. Let's start with found property, the difference between lost and abandoned property.
The foundational rule here is that you cannot steal abandoned property.
Abandoned property.
Right. If someone intentionally throws an item away with the clear intent to give up all rights and ownership to it, like tossing a broken chair into a public dumpster, that property has no owner, it is essentially returned to the state of nature. So if you walk by and take it from the dumpster, you cannot be guilty of larceny because you are not taking it from the possession of another.
But what if it isn't intentionally thrown away? What if it just fell out of someone's pocket?
If property is merely lost or mislaid, The original owner has not given up their rights to it. The law says the item is still constructively in the possession of the true owner.
So I can steal it.
Therefore, you can commit larceny of lost property. But as a finder, you are not automatically a thief just for picking it up. Two specific requirements must be met at the time you find it.
What are they?
First, at the exact time you find the property, you must either know who the owner is or have reason to believe you can find out.
Like an ID.
Exactly. If you find a wallet on the sidewalk and it has a driver's license inside, you have a clue to the owner's identity. If you find a generic, unmarked $10 bill blowing across an empty parking lot, you have no way of knowing whose it is.
That makes sense. And the second requirement?
Second, and this goes back to concurrence, you must have the intent to steal the item at the exact moment you take possession of it.
Let me play this out. I'm walking down the street. I see a wallet. I pick it up, open it, see an ID, and $300 in cash. I look at the cash, smile, and say to myself, today is my lucky day. I'm keeping this money. I put the wallet in my pocket.
That is larceny. You had a clue to ownership via the ID, and you formed the intent to steal at the exact moment you acquired dominion and control over the wallet.
Now let's change the timeline. I pick up the wallet, see the ID, and I think, oh man, someone lost their rent money. I'm going to mail this back to them tomorrow. I put it in my pocket. I go home. I put it on my kitchen counter. 3 days go by. I look at the wallet. I think about a bill I have to pay, and I get greedy. I take the cash out and throw the ID in the trash. I changed my mind. Is that larceny?
It is not common law larceny.
Really? Because I definitely stole it.
But your intent at the exact moment of taking possession on the street was innocent, right? You intended to return it. Because you lacked the intent to permanently deprive at the moment of caption, the elements of larceny do not align.
Wow.
The later decision to keep the money is certainly unethical, and it might violate modern statutes regarding found property, but it fails the strict timing test for common law larceny.
The microtiming is everything. Does that exact same logic apply to property delivered to me by mistake?
It applies perfectly. Misdelivered property follows the exact same rule. If a delivery driver hands you a package that is clearly addressed to your neighbor, you only commit larceny if you realize the mistake the moment it is handed to you, and you intend to steal it right then and there.
And if I don't realize?
If you accept the box honestly thinking it is something you ordered, open it an hour later, realize it is your neighbor's new laptop, and then decide to keep it, you have not committed larceny. At the moment you took possession from the driver, your state of mind was innocent.
Which brings us to one of the weirdest subsets of these timing rules, the container cases. This is a very specific MBE favorite. What happens if I buy something that holds other things, but neither I nor the seller knows what is inside?
Oh, yes.
Let's say I go to an antique store and buy a heavy, locked, used desk. The seller doesn't have the key. I take the desk home, force the lock open, and find a secret compartment stuffed with $10,000 in cash.
This is a fantastic hypo, because it forces us to define when possession actually transfers. Did you already have lawful possession of the cash before you found it?
I mean, I own the desk.
Right, but the legal test is whether the parties intended to transfer just the container or the container and its contents. When you bought the locked desk at the antique store, neither you nor the seller knew about the cash. The seller intended to sell you an empty desk, and you intended to buy an empty desk.
Okay, so I didn't possess the cash at the store. When do I possess it?
You do not obtain lawful possession of the hidden cash until the exact moment you discover it.
Wait, really?
Yes. The law basically pauses time. When you pry open that secret compartment and see the stacks of bills, the law treats that as the very first moment you take possession of the money. And at that exact moment of discovery, the concurrence rule applies.
So if I open the drawer, gasp, and immediately say, I'm keeping this, finders keepers, I commit larceny.
Yes, because at the moment you first acquired possession of the hidden contents, you formed the intent to permanently deprive the true, unknown owner of their property. You committed larceny in your own living room.
It is so strange to think that the law freezes the timeline of possession until my eyes physically see the hidden object. Now, I have to push back on this strict timing rule. We keep saying the intent to steal must exist at the exact moment of taking.
Yes.
But what if my initial taking was wrongful? Even if I didn't mean to steal it, does the law just let me off the hook if I change my mind later?
You are leading us perfectly into one of the most important legal fictions in criminal law, the doctrine of continuing trespass.
Continuing trespass.
Yes. The courts recognize the exact problem you were pointing out. They realized that strict concurrence Was letting bad actors get away with theft just because their initial mental state wasn't quite bad enough. So they invented a workaround.
Walk me through the workaround. Let's use the umbrella example again. I go onto my neighbor's porch and I take their umbrella without asking. I don't intend to steal it. I just intend to borrow it for the afternoon because it's raining and return it tonight.
Let's stop right there and analyze the initial act.
Yeah.
You took tangible personal property of another, and you did it by trespass, meaning without permission. It was a wrongful act. But because you intended to return it, you lacked the specific intent to permanently deprive.
Right. So on day one, I have committed a trespass, but not a larceny.
Correct.
But then it stops raining. I bring the umbrella into my house. The next morning, I wake up, I look at the umbrella, and I realize it's a really expensive, high-quality umbrella. I decide I'm not going to return it. I am going to keep it forever.
You formulated the intent to steal on day 2. Normally, because the taking and the intent happened on different days, there is no concurrence.
Yeah.
But the continuing trespass doctrine steps in.
Okay, what does it do?
The doctrine says that because your initial taking of the umbrella on day 1 was wrongful, it was a trespass, the law will pretend that your trespass continued every single second of every single day until the moment your mind changed.
Whoa.
Yeah. When you wake up on day 2 and decide to keep it, the legal fiction of the continuing trespass crashes into your new intent to steal. Concurrence is artificially created. Boom, you are guilty of larceny.
That is incredibly clever of the courts. But wait, what if my initial taking wasn't wrongful? What if I took the umbrella by honest mistake? Like, I went to a restaurant, left my black umbrella on a hook, and when I left, I accidentally grabbed someone else's identical black umbrella, honestly believing it was mine.
This is the crucial limit of the doctrine. If you take the umbrella by honest mistake, your initial taking is innocent. You genuinely believed it was yours. Because the taking was innocent, there is no trespass to continue.
So if I realize the mistake the next morning, see it belongs to someone else, but decide to keep it anyway.
It is still not common law larceny. The continuing trespass doctrine does not apply because there was no initial trespass. Your innocent state of mind on day 1 protects you from a larceny charge on day 2, even if you decide to act like a thief later.
That is fascinating. Think about the physical reality. In both scenarios, the physical action on day 2 is exactly the same. I am standing in my kitchen, looking at an umbrella, and deciding to keep it. But because of what was secretly in my head on day 1, a wrongful borrow versus an honest mistake, I either commit a felony or I don't.
Exactly. It's all about the mind.
Okay, before we move to the next crime, let's synthesize this. If I'm taking the bar exam, how should I mentally frame larceny?
Frame it as a timeline of possession. Ask yourself, who had possession first? Was it taken without permission? And exactly what was the defendant thinking at the very moment they took control of the item? If the taking was wrongful, but not intended as a theft, remember to look for a later change of mind to trigger continuing trespass. And always distinguish between mere physical custody and actual lawful possession.
Perfect. That covers the sneak thief. But the strictness of that possession rule created a massive loophole in society. What happens when the thief doesn't have to sneak around or break bulk or trespass at all? What happens when you voluntarily hand over the property to someone because you trust them and then they betray that trust? That brings us to part 2, embezzlement.
Embezzlement is the trust breaker. It is actually not a common law crime. It was created by early statutes, specifically to plug the gaps left by the strict rules of larceny.
Really? I didn't know that.
Yeah. The courts were tired of seeing employees and trustees walk free just because they had already been given possession of the property. Embezzlement is defined as the fraudulent conversion of the property of another by a person who is already in lawful possession of that property.
The big difference here is timing and permission. In larceny, the taking is bad from the very start. You never had permission to possess it. In embezzlement, you get the item legally. You are supposed to have it. And then later on, you do something criminal with it.
That's the essence of it, yes.
Let's look at the foreman tool hypothetical from the outline to see how this plays out on a test.
Okay, imagine a construction foreman. His employer explicitly gives him lawful possession of a very expensive heavy-duty power tool. The foreman is supposed to keep it in his truck, manage it, and use it across various job sites.
So he has broad authority over this tool.
Exactly, he has lawful possession. One day, while still happily employed, he takes the tool to a pawn shop and sells it for cash.
Okay, let's pause there. He already had lawful possession, so he didn't take it from the possession of another. It can't be larceny.
Right.
But he sold it. He converted it to his own use. That is embezzlement.
Exactly. Now let's continue the hypothetical. The foreman's boss finds out he sold the tool. The boss immediately fires him, tells him to clear out his truck, and bans him from the site.
Makes sense.
The foreman is furious. On his way out to his truck, he sneaks into the main supply closet, grabs a totally different power tool one he was never issued, and walks off the site with it.
For the MBE, what are his crimes? It feels like the exam will try to blur these two acts together.
They absolutely will try to blur them, but
Yeah.
you have to keep them separate. For the first tool, he had lawful possession by virtue of his employment trust. He fraudulently converted it. That is embezzlement.
Okay, and the second?
For the second tool, the situation changed. He had just been fired. He had no authority, no trust, and no right to possess anything in that supply closet. When he took the second tool, he took it from his employer's possession by trespass with intent to permanently deprive. That is larceny.
So the exact same guy, stealing from the exact same boss, commits two different crimes depending entirely on his employment status and possessory rights at the moment of the theft.
Exactly.
Now, notice the definition of embezzlement uses the word conversion. It doesn't use the larceny term carrying away or asportation.
That is a critical distinction. Embezzlement does not require moving the property. Conversion just means dealing with the property in a manner that is seriously inconsistent with the trust arrangement. You are exercising rights of ownership that you do not have.
I see.
And importantly, you do not even have to personally gain from the conversion to be guilty.
Wait, I can embezzle without keeping the money?
Yes. If you are the trustee of a large financial fund and you secretly siphon off $100,000 and donate it to a legitimate, highly respected charity, you are just as guilty of embezzlement as if you used that money to pay off your own gambling debts.
Even if I gave it to charity?
Yep. You took property entrusted to you and dealt with it in a way that violated the trust and permanently deprived the owner. The destination of the funds doesn't matter. The breach of trust does.
That makes sense. The crime is the betrayal of the authority given to you. Now, let's talk about the intent requirement, fraudulent intent. The outline highlights an MBE trap here regarding the intent to return property. If I borrow something without asking but intend to put it back, is that embezzlement?
It depends entirely on what you intend to put back. If you intend to return the exact specific property you took, it is generally not embezzlement because you haven't fraudulently converted it. You just misused it temporarily.
Okay, let me try an analogy to test this. Say I work at a high-end art gallery. I am the manager. I have keys, alarm codes, and lawful possession of the artwork. I am hosting a fancy dinner party at my apartment this weekend.
Uh-oh.
Yeah. I take a unique, original painting off the gallery wall, bring it to my apartment, and hang it up just to impress my guests. On Monday morning, I bring that exact same painting back to the gallery and hang it on the wall. No harm, no foul.
Under the strict definition of embezzlement, if you intend to return the exact unique property and you have the present ability to do so and you actually do it, you lack the fraudulent intent required for embezzlement.
Oh, wow. So I'm clear.
I mean, you might be fired, but you aren't an embezzler.
Yeah.
Let's change the facts slightly to demonstrate the trap. Let's say you work as a cashier at a bank. You have lawful possession of the cash in your drawer. You realize you forgot your wallet, and you need to buy lunch.
Okay, a very common scenario.
You take a crisp $20 bill out of your drawer. You fully intend to go to the ATM after your shift, get a different $20 bill, and put it back in the drawer tomorrow morning to balance the books. Are you guilty?
Well, I am replacing the exact value, $20 for $20. The bank loses nothing, so I should be fine, right?
You are guilty of embezzlement.
Right.
Yes, and this is a massive trap for the MBE. Money is fungible, but the law of embezzlement requires you to return the exact same physical property. Returning similar property, even identical cash of the exact same value, is still embezzlement.
That is insane.
When you spent that specific $20 bill on your lunch, you permanently converted that specific piece of paper to your own use. The fact that you intend to replace it with a different piece of paper tomorrow is legally irrelevant. You cannot replace your way out of an embezzlement charge.
Wow. So replacing the exact unique painting is fine, but replacing a $20 bill with another $20 bill is a felony. That is an incredible trap. If you are listening, write that down in big red letters. Intending to replace cash with different cash is still embezzlement.
Definitely write that down.
Okay, so we have the sneak who takes possession and the trust breaker who misuses possession. Let's move to part 3. What if the victim willingly hands the property to you right to your face, but only because you fed them a massive lie?
This is the roommate who lies about a family emergency to get your car keys. Now we are entering the territory of false pretenses, and its very confusing, annoying twin sibling, larceny by trick.
I know these two crimes cause endless headaches for law students. Let's start with definitions. What is false pretenses?
False pretenses is defined as obtaining title to the property of another by making a knowing false statement of past or existing fact with the intent to defraud.
Let's stop right there and highlight the most important word in that definition, title. The ultimate MBE distinction is title versus custody or possession.
It might be the single most tested distinction in property crimes. When you lie to someone to get their stuff, you have to look at what the victim actually intended to give you. If your lie convinces the victim to hand over mere custody or even temporary possession of the item, meaning they expect to get it back, the crime is larceny by trick.
Okay, because they never intended to give you ownership.
Right, your lie is just a trick to effectuate a taking. But if your lie is so good that it convinces the victim to transfer the official title, meaning full, permanent ownership, the crime is false pretenses.
Let's use the car sale example from the text to show the difference in action.
Go for it.
Let's say a guy named D wants to buy a car from a seller named X. D doesn't have any money. So D hands X a piece of paper and says, this is a promissory note signed by Y, a very famous, very rich person, saying Y owes me $10,000. But it's a complete lie. D forged the note himself.
A classic con.
Now we have two scenarios based on how the seller reacts. Scenario AX, the seller looks at the note and says, okay, I will sell you the car, but the sale isn't final and I'm not signing the title over until I actually go to the bank and collect the cash from Y. You can drive the car home and use it until then. D drives off.
In scenario A, what did the victim intend to transfer? X only gave D permission to use the car pending the final payment. X explicitly withheld the title. He intended to transfer temporary possession, not ownership.
So that's larceny by trick.
Because D used a lie to obtain possession. Exactly. The crime is larceny by trick.
Okay, scenario B. Same fake note from the rich person. The note says the money is due in 30 days. X, the seller, looks at the note and trusts the rich person's credit so much that X says, great, this note is as good as cash, the car is yours. X signs the official title of the car over to D, hands him the keys, and D drives off.
In scenario B, X intended to transfer full ownership, full title, right then and there. He didn't expect the car back. He thought he had essentially been paid. Because D used a lie to obtain the title to the property, the crime is false pretenses.
It is entirely about the victim's state of mind. Did the victim intend to give you temporary control? Larceny by trick. Did the victim intend to give you total ownership forever? False pretenses. And cash is tricky here, right? If I lie to get cash, is that possession or title?
If you lie to get money, and the victim hands you cash intending for you to keep it, like giving you a fake charitable donation title to the money, passes with possession. So obtaining cash through a lie is almost always false pretenses.
Okay, let's drill down into the rules of the lie itself. What kind of lie actually counts for false pretenses? Does any fib work?
No, the law is actually quite strict about what constitutes a criminal lie. First, the lie must be about a material fact. It cannot just be an opinion or sales talk, which the law calls puffing.
Puffing.
Yeah, if I am trying to sell you my used car, and I falsely say, this is the best driving car in the world, you're going to look amazing in it, that is just an opinion. It's puffing. It's not a crime. But if I say, this car has a brand new transmission installed yesterday, and I know the transmission is busted, that is a false statement of fact.
And what about the timing of the fact? This is an area where I know common law and modern law diverge significantly.
Yes. At traditional common law, the lie had to be about a past or present fact. A false promise to do something in the future did not count for false pretenses.
So if I knock on your door and say, give me $1,000 right now, and I promise I will paint your house tomorrow, and I know full well I am taking the next flight to Vegas and never painting your house, under common law, that wasn't false pretenses.
Correct. Under strict common law, a false promise regarding future conduct was not sufficient. The logic was that people shouldn't be criminally punished just for breaking contracts or changing their minds later.
Oh, that's a huge loophole.
It was. Modern law, influenced by the Model Penal Code, recognized that this is a huge loophole for con artists. So under modern statutes, a false promise made with the present intent not to perform is sufficient for false pretenses. You have to read the call of the question on the MBE very carefully. If it asks about common law, future promises don't count. If it asks about modern law, they do.
Furthermore, the victim must actually be deceived by the lie, right?
Exactly. The lie must be the major inducing cause of the victim handing over the title. If the victim knows you are lying, but gives you the car anyway just out of pity, or because they were going to throw it away regardless, you have not committed false pretenses.
Even though I lied.
You might be guilty of attempted false pretenses, but the substantive crime requires the victim to actually be fooled.
And what about the defendant's state of mind regarding the lie? Obviously, I have to know I am lying, but what if I just suspect it's a lie and don't check?
If you are put on notice that your statement is probably false, and you deliberately avoid learning the truth, a concept called willful blindness, or sticking your head in the sand, the law treats that the same as actual knowledge. You can't shield yourself by refusing to look at the facts.
But what if I am just an idiot? What if I make a statement that is totally false, but I honestly believe it is true? Even if my belief is completely unreasonable.
If you honestly believe your statement is true, no matter how unreasonable or foolish that belief is, you are not guilty of false pretenses. The crime requires the specific intent to defraud. An honest, albeit stupid, mistake of fact negates that specific intent.
All right, let's take a breath and synthesize the big three before we move on to the violent stuff. If I am staring at a messy fact pattern on the exam, how do I quickly categorize them?
It all comes back to how the defendant acquired the property. Look at the moment of acquisition. If they got possession by taking it without permission, it's larceny.
Okay.
If they already had lawful possession because of trust but then criminally converted it, it's embezzlement. If they got possession because they told a lie, it's larceny by trick. And if they got full title and ownership because they told a lie, it's false pretenses.
That is the cheat code right there. Sneak, trust breaker, custody liar, title liar. Okay, let's turn the volume up. We have spent the first half of this deep dive looking at quiet crimes. Crimes of stealth, broken trust, and deception. Now we need to look at what happens when the thief abandons the quiet approach and uses fear. Let's talk about the violent upgrades, robbery and extortion.
Robbery is the one everyone knows from the movies, but the legal definition is very specific. Robbery is essentially an aggravated form of larceny.
How so?
It contains all 6 elements of common law larceny: taking, carrying away tangible personal property of another by trespass, intent to steal. But it adds 2 massive aggravating factors. The property must be taken from the victim's person or presence, and the taking must be accomplished by means of force or intimidation.
Let's deep dive into those 2 extra elements, starting with force or intimidation. How bad does the threat have to be? If I walk up to someone and say, "Give me your wallet or I will step on your toe," is that robbery?
Well, if you actually use physical force, it just has to be enough force to overcome the victim's resistance. Snatching a purse from someone's tight grip is force. But if you rely purely on threats and intimidation, the common law requires the threat to be of immediate death or serious physical injury to the victim, a family member, or someone currently present.
Okay, so stepping on a toe doesn't count.
Threatening to step on a toe probably doesn't rise to the level of serious physical injury.
What if I threaten to smash their car with a baseball bat if they don't hand over their watch?
Generally, threatening property damage does not count for robbery. The fear must be for personal safety. However, there is one weird, highly specific historical exception.
Oh, I love these. What is it?
Threatening to destroy the victim's dwelling house does count as sufficient intimidation for robbery. But aside from that quirk, look for threats of immediate physical harm to a person.
Okay, what about the presence requirement? Does the property have to be physically touching them? Right out of their hands.
No, presence is defined much more broadly than physical contact. Property is considered in the victim's presence if it is in their immediate vicinity, and they would have been able to retain control over it if they hadn't been subjected to force or fear.
Can you give me an example?
A classic example.
Hmm.
If a burglar breaks in, ties the victim up in the downstairs living room, and then goes upstairs to steal jewelry from the bedroom, the law considers the jewelry to be taken from the victim's presence. The victim could have protected the jewelry if they weren't bound by force.
That makes sense. Now here is a timing question that I know the examiners love. When exactly does the force have to happen? What if I take the property completely peacefully by stealth, but then I have to use force to get away? Let's use the pickpocket example.
The pickpocket scenario is a perfect test of the continuing nature of a robbery. Imagine a thief on a crowded subway. He reaches into a woman's coat pocket without her knowing. It is totally stealthy. He removes her wallet. At this exact moment, the taking is complete, and it was done without force. It is larceny. But the moment the wallet clears her pocket, the woman feels a tug, turns around, and grabs the thief's arm to stop him. The thief punches her in the face, knocking her out, and runs away with the wallet at the next stop. Is this robbery?
Well, the initial caption and asportation were stealthy. The force happened after the taking.
True. But the law has adapted to this. The rule is that the force or threats must be used either to gain possession or to retain possession immediately after the taking. Because the thief used violent force to prevent the victim from immediately regaining her property, the force relates back to the taking. The stealth crime escalates into robbery.
Got it. Force used during the immediate escape turns a quiet sneak into a violent robber. Now, what about extortion? People colloquially call it blackmail. Extortion is defined as obtaining property by threats. How is extortion fundamentally different from robbery? They both involve a bad guy using threats to get your stuff.
The MBE distinction between robbery and extortion comes down to timing and location. They're essentially mirror images of each other regarding the threat. In robbery, the threat must be of immediate physical harm, and the property must be taken from the victim's presence.
And extortion?
Extortion is the opposite. In extortion, the threats do not need to be of immediate harm. It could be a threat to do something in the future. The harm does not need to be physical. It can be threatening to reveal an embarrassing secret or file false criminal charges or ruin their business reputation. And the property does not need to be taken from the victim's presence.
Let me set up a hypothetical. If I call you on the phone on Tuesday and say leave $10,000 in a briefcase under the park bench on Friday, or I will post your internet search history online for your boss to see, that is extortion.
Exactly. Let's run it through the differences. Is the threat immediate? No, it's for Friday. Is the threat physical harm? No, it's reputational harm. Are you taking the property from my presence? No, I'm leaving it under a bench. It hits every element of extortion and fails every element of robbery. That is the dividing line.
That is a very clean distinction. Robbery is immediate, physical, and in your face. Extortion is future, often non-physical, and from a distance. Okay, let's move to part 5. Let's look at the aftermath of the crime and the paperwork that facilitates it. The thief has escaped with the goods. The robbery or the larceny is completely over. But what about the people who handle the goods next? Let's talk about receipt of stolen property.
This brings us to the fence. The person buying the stolen goods out of the trunk of a car in a dark alley. The elements of the crime are receiving possession and control of stolen personal property, knowing that it has been obtained criminally with the intent to permanently deprive the true owner.
When you say receiving, do I have to physically take the item into my hands?
No. Receiving possession doesn't require manual touch. If you pay the thief and then direct the thief to go hide the stolen TV in a specific storage locker that you control, you have received it. You exercise dominion and control over it.
But the key to this crime, and the place where the MBE loves to trap students, is the stolen status of the property itself, right? I want to spend some time on the undercover police trap because it is notoriously tricky. Walk us through that.
This is a trap that catches so many test takers because it feels like a trick question, but it's based on strict legal logic. To be guilty of receiving stolen property, the property must actually legally be stolen at the exact moment you receive it.
Okay.
Imagine a thief breaks into a house and steals a flat-screen TV. The police pull the thief over an hour later, arrest him, and recover the TV. The TV is sitting in the police station. The police then call the true owner and say, "We caught the guy. We have your TV. But we know he was going to sell it to a notorious local fence. Can we use your TV in an undercover sting operation to catch the fence?" The owner agrees and gives the police permission to use the TV.
Okay, so the police load the TV into an unmarked van, and an undercover officer drives to the alley to meet the fence.
The undercover officer tells the fence, "Hey, I just stole this TV. I'll sell it to you for $100. The fence laughs, says, "Great," pays the $100 and takes the TV, fully believing it is stolen with every intent to fence stolen goods. The police arrest him. Is the fence guilty of receipt of stolen property?
Every instinct says yes. His intent is totally criminal. He bought a TV that was taken in a burglary.
But the answer is no.
Yeah.
He is not guilty of receipt of stolen property.
Wait, why not?
And here is why. The moment the police recovered the TV on behalf of the owner, and especially once the owner gave permission for the police to use it, the TV legally lost its stolen status. It was recovered property being used with consent. You cannot receive stolen property if the property isn't actually stolen at the moment of receipt. It is a legal impossibility.
That is incredibly sneaky of the examiners. They build up all these bad facts to make you hate the fence, but the actual status of the item protects him.
Now be careful. The fence is not going to walk away entirely free. Because he believed it was stolen and intended to buy it, he has taken a substantial step toward committing the crime with a criminal mental state. He is almost certainly guilty of attempted receipt of stolen property. But if the multiple-choice question asks if he is guilty of the substantive, completed crime of receipt, the answer is definitively no.
That is a brilliant trap. Read the call of the question, attempt versus completed crime. Okay, moving on to the fakes. Forgery. It is defined as making or altering a false writing with intent to defraud. What is the trick here? We all know what a forged signature is.
The first major trick is the concept of apparent legal significance. Not every lie written on a piece of paper constitutes the crime of forgery. The writing must have some sort of legal weight or consequence or establish some sort of right or liability.
Let me try an analogy to see if I grasp this. If I'm mad at my roommate and I take a yellow sticky note, write, "I promise to pay you $1,000,000," and sign Elon Musk's name to it and stick it on the fridge. It's a lie. I forged his signature, but it obviously has no legal meaning. Nobody would believe it. I can't be arrested for forgery for a joke on a sticky note.
Exactly. The document must look like it could actually affect legal rights. Let's look at the letter example from the text, which is much more subtle. Let's say you are applying for a job. You draft a glowing fake letter of recommendation, and you sign a former employer's name to it. Is that forgery?
I would assume yes.
Yes, because a recommendation for employment has apparent legal significance. It could affect hiring, and an employer could potentially face legal liability or reputational damage if they give a false recommendation. But what if you draft a fake letter of social introduction to get invited to a private country club party? That only has social significance. It does not create legal rights or liabilities. It is not forgery.
What about faking a piece of art? If I paint a portrait, make it look really old, and forge the signature Rembrandt at the bottom, am I committing forgery?
No, not under common law forgery. Writings are objects that derive their value purely from the fact of their physical existence or aesthetic merit, like historical documents, or a painting or a first edition book, cannot be the subject of forgery. The signature on the painting doesn't create a legal right. It just identifies the artist. Now, if you take that fake Rembrandt and sell it to an art dealer by lying to them about its authenticity, you just committed false pretenses. But the act of painting it and signing it is not forgery.
Okay, here is another tricky rule from the outline. You said the writing itself must be a lie. What does that mean? How is a document a lie?
It means it is not enough that a real, authentic document contains a false statement of fact. For a document to be a forgery, the document must represent itself to be something that it fundamentally is not. It must have fake authenticity.
Can you break that down?
Sure, let's look at two warehouse managers to see the difference. Manager A is the authorized legal manager of a grain silo. He's allowed to issue official receipts. One day, he writes an official receipt saying he received 100 tons of grain, but he actually received 0. He signs his own name. Is this forgery?
Well, he lied on an official document.
He lied, yes. But the document itself is exactly what it purports to be. It is an official receipt issued and signed by the authorized manager. The facts inside the document are false, but the document's authenticity is real. Therefore, it is not forgery. He is guilty of fraud or false pretenses if he uses it to get money, but not forgery.
Okay, what about Manager B?
Manager B is actually just a janitor. He has no authority. He steals a blank receipt form from the office. He fills it out saying 100 tons of grain were received, and he signs Manager A's name at the bottom. Is this forgery?
Yes, because the document purports to be an official receipt authorized by Manager A, but it is actually a fake created by a janitor. The document itself is pretending to be something it is not.
Precisely. If an authorized person lies on a real form, it is fraud, but not forgery. If an unauthorized person makes a fake form look real, it is forgery. The document itself must be a lie.
That is such a fine line, but it makes total sense when you break down the concept of authenticity. Okay, we are in the home stretch. We have to talk about what happens when the bad guy's goal isn't to steal the property, but just to ruin it. Pure damage. Malicious mischief.
This is the roommate who gets mad at you and just smashes your laptop against the wall. Malicious mischief is the malicious destruction of or damage to the property of another. It is important to note for the exam that you do not have to completely destroy the item to be guilty. If you merely impair its utility or materially diminish its value, that is sufficient. Taking a key and scratching the paint down the side of a car counts as malicious mischief.
The outline specifically highlights the word malice. In normal conversation, malice means hatred or spite. Do I have to hate the person to be guilty of malicious mischief?
No. That is a very common misunderstanding that trips people up. Malice in this specific legal context does not require ill will, spite, or hatred toward the owner. It simply requires that the damage or destruction was intended or contemplated by the defendant. If you intentionally throw a heavy rock off a bridge just to watch it smash a car windshield, you acted with malice toward the property, even if you have no idea who owns the car and hold no hatred toward them.
So malice just means you meant to cause the damage. Okay, before we wrap this up, we need to address the modern world. We have spent this entire deep dive talking about incredibly strict, rigid common law boxes. We debated custody versus possession, caption versus asportation, whether a document is a lie, and the timeline of severed trees. But the real legal world has changed over the last century, hasn't it?
Yes, dramatically. Modern statutory codes, heavily influenced by the Model Penal Code, have substantially altered and modernized these rules. The legislatures recognized that the common law had become too convoluted, filled with too many fictions like breaking bulk and continuing trespass, just to make the logic work. The biggest change is the consolidation of offenses. There's a massive trend in modern jurisdictions to take larceny, embezzlement, false pretenses, and sometimes even receipt of stolen goods, and smash them all together into one giant comprehensive crime, simply called theft.
So under modern law, if you take my car, it doesn't matter if you snuck into my driveway or kept it after a lease expired or lied to me to get the title, the prosecutor just charges you with theft.
Exactly. The modern focus is on the unlawful acquisition of someone else's property, regardless of the subtle mechanics of how it was done. Furthermore, modern laws are dropping the ancient technicalities. Many jurisdictions have eliminated the asportation or carrying away requirement completely. You just have to obtain unlawful control over the item. And they have expanded the definitions of property to explicitly cover digital services, intellectual property, and intangibles that the common law couldn't even fathom.
So if modern laws have fixed all these convoluted loopholes, why did we just spend an hour agonizing over the ancient common law rules?
This is my final, most important warning to anyone taking the MBE. Listen carefully. Even though modern state legislatures have combined these crimes into generic theft, the multi-state bar examination still extensively tests you on the old separate common law categories. The examiners love the technicalities because they are perfect for multiple choice questions. They love testing whether you know the difference between custody and possession. They love testing breaking bulk, innocent agents, and the merger of documents. You absolutely must know the common law boundaries to pass this test. If a question specifically asks, under modern consolidated theft statutes, what is the result, then you apply the broad rules. But otherwise, you assume you are operating in the strict, unforgiving world of the common law.
Do not let the simplicity of the modern world trick you into forgetting the complexity of the old rules. Well, we have made it through the gauntlet. We survived the bad roommates, the tricky store clerks, the forged receipts, the pickpockets, and the police stings. If you are listening to this while studying for the bar right now, we know how exhausting this process is. Your brain feels full. But you can do this. Keep the functional logic of these rules in your head. Don't just memorize the words, visualize the timeline. Focus on custody versus possession, focus on title versus temporary control, and always look at the exact microsecond the intent formed.
You absolutely have got this. Take the questions one element at a time.
Mm-hmm.
And as we finish up, I want to leave you with a philosophical thought to ponder as you review your notes tonight. It goes back to that bizarre doctrine we discussed earlier, continuing trespass.
The umbrella example, where the law freezes time.
Think about how strange the underlying logic of the law truly is. Physical reality doesn't change, but your internal, secret mind dictates your fate. If you take an umbrella by honest mistake on day one and later decide to keep it on day two, you are completely innocent of larceny. But if you take it on purpose just to borrow it on day one and later decide to keep it on day two, you are guilty of a felony. The physical action in the real world, holding the umbrella in your kitchen and deciding to keep it on day two, is exactly the same in both scenarios. But because the law cares so deeply about the precise microsecond a bad thought pops into your head, your secret inner thoughts on day one retroactively and completely change your criminal liability on day two. The law doesn't just judge what your hands do, it judges the timeline of your soul. Something to ponder the next time you accidentally grab the wrong coat at a restaurant.
The timeline of your soul. I love that. Keep studying, keep fighting through the outlines, and we will see you on the next deep dive.